Hello, I'm Jo Natoli, Principal of the Rental Specialists. Welcome to our 10th video in our 15-part series on the changes to the Residential Tenancies Act that came into effect on the 23rd of March 2020. Today we're discussing landlords' private information. The residential tenancy laws require that landlords provide their name and either a telephone number or an email address to their tenant. These details must be given to the tenant even if the landlord uses an agent, and they are to be noted on the front page of the lease agreement. Property managers need to ensure that they don't nominate their own contact details instead of the landlord's direct contact details. Where the landlord is not using a property manager, then the landlord must also include their name and their residential or business address. And in the case where the landlord is a corporation, the landlord must also include the name of the corporation and the business address of the corporation. Tenants must be given this information in writing before they sign the residential tenancy agreement, or it can be included in the residential tenancy agreement. Tenants must also be informed in writing within 14 days of any change to the landlord's or the agent's details during the tenancy. Now, this isn't actually a new piece of legislation. The requirement to provide this information to tenants was actually written into the 2010 Residential Tenancies Act. What we're seeing now with the 2019 Act is enforcement to provide this information. There are some landlords who are concerned about providing their private details to a tenant. I understand that perfectly, and indeed the same concerns crossed my own mind. The premise behind this enforcement of this point is twofold. Firstly, where a property manager is less than ideally responsive about important matters such as repairs and maintenance, it provides an avenue for the tenant to bring the matters to the landlord's attention where they otherwise may not have known about the matter. And secondly, where a tenant needs to serve documentation to the landlord, for example, a copy of an application to NCAT, the tenant has somewhere to serve it. Out of interest, this has been a requirement in South Australia for quite some time, and the anecdotal feedback we've received is that tenants will still, in the vast majority of cases, communicate with the property manager at the first instance. We will continue to educate our tenants that we're the property managers acting on behalf of the landlords and that they should be contacting our office for any matters that arise. We've also been proactive and inserted an additional question into our management agency agreements where we are requesting that the landlords provide us with a dedicated email address specifically intended to insert into the lease agreement. If you'd like any further information about any of these new laws and how they may apply to you, please feel free to be in touch with us. We'd be happy to help.